I got a video clipping of that, and today again I will take the opportunity along with my other colleagues to learn more. And already we are 135 participants. And for today's program, usually we have the capacity of 100 participants, but we have increased it to 500 so that more of our members can join. And these are increasing gradually. So it is all because of the attraction of the star speaker, Kapil Goel ji, and our learned past presidents, अपने Ganesh Purohit ji, Prem Lata बहन, and we have VP Gupta ji and Rajesh Mehta ji. Within the given time, I think they should also enlighten us little bit on the budget propositions without repeating. So thank you very much, and once again I welcome you all. Back to Gupta ji.
May I request Mr. Kapil Goel to start, please?
Thank you, Gupta sir. Sir, am I audible, sir?
Yes,
Yes,
very well.
yes.
All my seniors and my colleagues and friends who are present in this meeting, Gupta ji, you have made me to be here today, this evening. And I want to convey my regards to everyone. I'm not taking the name, but when I am in this family of AIFTP, I feel always blessed and especially blessed as Lord Banke Bihari is very near to me in form of all of you. And when I see you, Gupta ji, personally, it is no doubt that you are looking most handsome. That is a depart. I will not defocus myself from that. But I am telling you that you are so charming always from your words. And Narayan Jain Sahab, AIFTP President, Senior Advocate Prem Lata Bansal Ma'am, Purohit Sahab, Mehta ji, and Kakra ji, and everyone, sir, who are present here. So my duty is to just, sir, and I am telling Gupta ji, humbly submitting rather, that this family of AIFTP, in this family of AIFTP, as far as what you say seniority goes, I am very junior. And you have given me a duty to perform. I will definitely try my level best, whatever little I know, limited. But with all due humility at my command, Narayan Jain Sahab, that all in this family are very senior to me. I'm nobody to, what you say, tell anybody anything. Rather, I'm very younger in this family. So whatever I'm speaking and submitting is with that feelings only, sir. So Gupta ji, this budget, as Jain Sahab has stated, that this is a long budget. And when you read the finance bill and memorandum, the number of pages and folios which are there, it tells how lengthy the budget is. So when you make a macro analysis of the budget or micro analysis, there are two types of analysis. Macro analysis, if you make, right from section 2 to section 276 capital B, the amendments are there. Apart from that, Vivad Se Vishwas part 2 has also come. So there are some very positive things also. There is no doubt. But there are some really, what you say, worrying things, or I would say, in most chaste words, there are some challenging situations also which will come in the times to come, sir. As far as the my opening, what you say, remarks are concerned, sir, submissions are concerned, there are, they have said, the Honorable FM has said that entire Income Tax Act will be comprehensively reviewed in the times to come in next 6 months. So that is one thing, Gupta ji, that taxpayers and tax consultants, and as far as this body, Apex Accounting Taxation Body, will be, you people will be always will be busy with all these things which will come in the times to come. So there is one thing, but apart from that comprehensive review which will be done in the future, they have taken 5 subjects for this particular finance bill, which are capital gains, which are charitable trust, which is reassessment, which is search assessment, and which is TDS, sir. So 5 things they have taken, Jain Sahab, in this particular finance bill for starting as a matter of review. So I repeat, TDS, charities, reassessment, search assessment, and capital gains. So we will try to take as much as we can do, sir. And one thing Honorable FM has stated in the finance, this budget speech, that the appeal limit of this appeal limit for filing appeal before the ITAT, High Court and Supreme Court, Gupta ji, has been increased, respectively for the Tribunal, High Court and Supreme Court to 60 lakhs, 2 crore and 5 crore. So that is very important, Gupta ji, I believe whenever the circular will come in the times to come, the Honorable Finance Minister in the budget speech has stated that they have increased the monetary limit of filing appeal before the Income Tax Appellate Tribunal, High Courts and Supreme Court, respectively to 60 lakh rupees, to 2 crore rupees and 5 crore rupees, which was earlier 50 lakh, 1 crore and 2 crore. So, as somebody was saying, whether this limit which will be enhanced will be applicable to the cases which will be pending in the cases, old cases. As has been the past, it should be. But it depends upon the circular which they will bring to accommodate this new enhanced monetary limits. So one thing, this is positive change to reduce litigation. Second positive change at the outset is Direct Tax Vivad Se Vishwas 2024. Positive, I am saying, Jain Sahab, because of this reason, that the litigation can be reduced by this. And many people, Gupta ji, whose appeals are pending at various cases, High Court, Supreme Court, ITAT, and various forms, they can take recourse to this. And as the time permit, we will discuss it also. So they have kept the cutoff date, specified date in Direct Tax Vivad Se Vishwas scheme for 22nd July 2024. So the appeal which is pending on 22nd July 2024 will become eligible for a declarant to opt this. And there are two types of slabs given. How much amount of tax will have to be paid in this Direct Tax Vivad Se Vishwas 2024. One thing which is very important, Gupta ji, underlying, as they have, I believe, government is also learning from its past experience, Jain Sahab, in this Direct Tax Vivad Se Vishwas scheme, in one criteria where they say who people will not be eligible to opt for this, very important thing which they have written, one should note is, Gupta ji, you may correct me if I'm wrong, that, that they say any assessment which is being done under section 143, subsection 3, 144, 147, 153A, 153C. If it is on the basis of Mehta Sahab, any search, etc., under section 132, then it will become ineligible. So there are various assessments under 148 and 143.3 which have footprints of search from the other people. So now this was a controversy in Vivad Se Vishwas 1. Now they have clearly stated they will not be eligible here. So I mean to submit that if this chunk goes, then it becomes another matter how many people remains. Because when you see the various assessments in which such footprints are there, then definitely it has to be taken into account. Rest, it is good. They have what litigation was going on in first Vivad Se Vishwas, Jain Sahab. They have captured those points and corrected in this 2024 scheme. I will take at the end other things which we depending upon Gupta ji, Chairman Sahab of the session, suggest me. So I start with Gupta ji, capital gains changes. And they go from section 2, clause 22, which is the definition of what dividend. And this changes, I am discussing first part of change in capital gains regarding buyback tax. Now, buyback tax, this change is in section 2, clause 22. They have inserted clause F, saying that if a company buybacks its shares, then it will be treated, Jain Sahab, as dividend in the hand of the shareholder. And it will be taxed in the hands of the shareholder under the head other sources, that is section 56. And no expenditure will be allowed against this, taxation in section 57. Gupta ji, they have clarified, section 57.
Right.
Now, the cost part is a very anomaly, that the cost which has been there in the hands of the shareholder, qua buyback shares, they say that whenever subsequently the shares will be sold, the set-off can be claimed. And first loss can be carried forward and then it can be set off in the subsequent years. So two changes are there. One change is this, that buyback from 1st October 2024, the cutoff date is 1st October 2024 for this change, buyback change. The buyback which will happen after 1st October 2024, Jain Sahab, will be taxable in the hands of the shareholder and as dividend, as income from other sources, no expenditure allowed, it will be taxed on gross basis. As far as set-off of loss is concerned, they have made amendment in section 46 capital A. They say deemed consideration will be nil against these shares and it will result in loss under capital gains, and loss will be carried forward in the next years and it will be set off depending upon the gains available to the taxpayer. So as far as taxation of the gross amount is concerned, that is one part. But Gupta ji, as far as living cost part, and with the expectation that some gain will arise to the taxpayer in the future and he will be able to set off, is something which is definitely paining various taxpayers. And definitely this is an amendment which is also debated by people who are dealing in stock markets. that whether this change is a positive change or is a progressive change or it is a regressive change. So I'm nobody to comment upon it, but the change I have explained that section 2 clause 22 clause F is added. It will be taxed under the head other sources. Section 57 no expenditure will be allowed, and section 46A it will be deemed consideration will be nil and loss will be carry forward, sir. And 115 QA also, Gupta ji, 115 QA, the earlier regime of buyback tax, they have put a sunset clause that after 1st October it will not apply. And under section 115 Q capital A. So these are the 4 changes, Jain Saab, as far as buyback of shares is concerned, which they have made. And the cutoff date is, I repeat, 1st October 2024. Second set of changes, Gupta ji, is very serious. Am I audible, Gupta ji, properly?
Yes, very well, very well. Please.
If there is anything you can please tell me, I can repeat, sir. Sorry.
No, it's perfectly okay.
As Bhaskar Saab was saying, I am trying to perfect my camera and voice both. Section 3, the second part of...
Kapil, in regard to this capital gain, buyback shares, this loss on capital gain, can it be set off in the same year against any other capital gain? Because the example they have given, the sale of the same shares subsequently. So, what is the intention? What is your view on this?
Sir, मेरे को तो उसमें, in due respect, in my respectful submission, you may correct me, as what they have written in the memorandum and what they have explained in the memorandum and what they have given an arithmetical example in the memorandum, yes. I don't know how it goes justified from the, there is no substantive corresponding change in the law to that, as far as my little knowledge goes. Now, if you go to the treatment of the loss, etc., in section 70, 71, 72, there is no change. There is no change.
Right. So, with that way, this loss can be set off against any other gain if I have during the year itself.
Because yes. Unless there is any bar in section 70, 71, 72.
Right. So, why
my treatment of loss, sorry if I am not wrong, Gupta ji.
No, you are perfectly right. That is my idea, view also. But why they have given their example of the sale of the same shares subsequently?
I don't know. Sometimes English language and sometimes what you say, over explanation sometimes harms us.
Sir, to my mind, that is also to be set off in the same very year,
yes,
in which the amount is treated as deemed dividend.
That's it.
Under 22F.
Ma'am, to my mind,
that is okay. Point is loss.
My mind says me one thing. If you correct me, Premlata ma'am, that this change, see, can the lawmaker say that we will tax you on the gross amount at one place and we leave cost at the other in its own manner? This is a question of a very, in an academical sense, as a student of law, I ask this question to myself also. That if you say that we will tax the gross amount and not give you any expenditure, even my legible cost, and then we will leave, Gupta ji, this cost to be set off against something else.
So in any way, but it appears that loss can be set off against any other capital gain.
Yes,
that is in the same very year.
Yes,
please.
Kapil ji,
same year or subsequent year whatsoever.
Kapil ji, this
if
is
same year it cannot be adjusted, then carry forward.
Kapil ji, Prakash Sinha sir this side.
Yes, Sinha ji.
Yes sir, सबसे बड़ा problem है not from the treaty provision से related काफी provision problem है sir. If we see the treaty, कहीं से dividend कहीं से disturbance आ रही है. Treaty में dividend not defined. Treaty में dividend defined नहीं है sir.
Right, Sinha ji.
और dividend disturbance आ रही है.
Sinha ji, can you reserve your question for some time? We can take it at the end.
Yes. मैं बीच कुछ disturbance आ रही है इसलिए मैं नहीं बोल पा रहा.
I'm sorry. I'm always happy to receive your interjection. मतलब sweet things. आप kindly bear with me for some time. I will rejoin. We may just reconnect of this query. So, can I progress, Gupta ji? Ma'am, can I go further?
Will carry on. Yes.
Ma'am, second set of changes is very serious. That regarding this classification of long-term and short-term and the treatment of long-term capital gains. Now, there is a very serious issue, ma'am, going on, and you being our senior counsel and Purohit Saab, that whether lawmakers have very high, latitude in making the laws under constitution. But when they make these changes like this, that they fix the cutoff date on the very same day of the budget, and bring it into the immediate effect, and now creating a very serious kind of a, what you say, classification that for the people who are earning long-term capital gain, Jain Sahab, prior to 23rd July 2024 and after that.
Yes.
So this is very typical that even they are not giving that time now in this particular thing that a person can adjust himself by the time finance bill becomes a finance act. So in that interregnum period is also not there. They have brought these changes of capital gain, which we are now discussing, from immediate effect. Now, first change they make is section 2 clause 42 capital A, period of holding. They say only two period of holding now will be there, 12 months and 24 months. 12 months for listed assets and 24 months for all other assets. Now, this is a simple classification. They say 12 months for listed assets and 24 months for all other assets. As far as period of holding is concerned, as far as short-term capital gain asset and long-term capital asset is concerned. Now, second corresponding change is regarding the rate of tax. Now, as far as rate of tax goes, ma'am, the change has been done in section 111A, 112, 112A, Purohit Sahab. Now, what they say as far as short-term capital gain is concerned on the listed things, listed assets, that will increase Sinasa from 15% to 20%. Now, that is also immediately applicable, ma'am. That is, I believe, the ceiling has been, date has been 23rd July only. These changes are all capital gain changes, which I am now discussing, with immediate effect they have enforced. So this rate change of short-term capital gain under section 111A from 15% to 20% on listed assets is immediately applicable. Second change of rate, which is very, very interesting and creating a lot of Purohit Sahab queries. My own father asked me one query that if I have a long-term capital gain, beta, what kind of treatment I will gain, what impact it will have. Now, change is like this in long-term capital gain. They make amendment in section 48 proviso, second proviso, that indexation benefit will no longer be available, sir, after 23rd July 2024. 24, ma'am. Am I right, ma'am? Prem, Lata, ma'am?
Yes, yes.
So they, when they have taken the benefit of indexation for the this after this date 23rd July 2024, they have also made change in the rate of long-term capital gain. They have made a single rate of long-term capital gain across both 12.5% under section 112 and 112A, Jain Sahab. So long-term capital gain change goes like this. It is across the board. It is for all capital assets. It is not like short-term capital gain change. It is like this, that all types of capital assets under long-term capital gain will attract the tax rate of 12.5%, henceforth 23rd July 2024. And no indexation benefit will be given. Now, taking away the benefit of indexation under section 48 by making amendment in second proviso to 48, and making a singular rate of 12.5%, many, as I was saying, that whether it will leave the taxpayer with a in a dearer situation or in a uncomfortable situation, it will depend upon maths. But definitely taking away the benefit of indexation, ma'am, will somewhere create some more tax effect, some more taxable gains in the hand of the taxpayer, and he will have to definitely reinvest more capital gain under section 54, etc. That is the takeaway. Am I right, ma'am? You want to add anything?
No, carry on.
So this change is like this, that they have changed the rate of tax of long-term capital gain across board 12.5%. They have taken away the benefit of indexation and it is immediately applicable. And short-term capital gain wala change is for only listed thing 15% to 20%. Third change, yes, ma'am, please. You want to say something?
Yes. As far as section 112A is concerned, first limit is enhanced from 1 lakh to 1.25 lakhs.
Yes.
And I think that so far as long-term capital gain is concerned, under for listed securities, it is 12.5%. But so far as unlisted securities are concerned, then I think that would be higher rate of tax, no?
No. Long-term capital gain for all the assets, as Kapil has rightly said, is 12.5%.
12.5%.
Okay.
In respect to everything.
गुप्ता जी, इससे कम होगा टैक्स, ज्यादा होगा? सॉरी,
देखिए, जो पुराने प्रॉपर्टीज में तो जनरली जो है लॉस होगा। प्रॉपर्टीज में तो जो है इंडेक्सेशन से काफी एडवांटेज हो जाता था। जो आप शेयर्स में बात करोगे 1 साल के बाद ही बेच दिया, उसमें एडवांटेज हो सकता है। पहले तो 10% था, उसमें तो लॉस होगा। पर जहां अगर जो किसी सिक्योरिटीज में 20% लग रहा था और 2 साल के बाद बेच रहे हो तो शायद उसमें गेन हो जाएगा।
हाँ, जो जैसे आपका कहने का मतलब है कि जैसे जिसने लॉन्ग टर्म जैसे 2-4 साल का है, जैसे जैसे फॉर एग्जांपल इफ आई रिफाइन इट कि 2001 के बाद फेयर मार्केट वैल्यू के बाद का गेन है, जहां आपके फेयर मार्केट वैल्यू का भी ऑप्शन नहीं है,
करेक्ट,
तो वहां पर डेफिनेटली इसका बर्डन बढ़ जाएगा,
बिल्कुल बढ़ जाएगा। अभी
सर,
तो
मुझे
मोस्टली
लग
अगर
रहा है कि
2001 से लें तो वो बराबर सेल प्राइस के बराबर आ जाती है वैल्यू जो है।
हाँ जी, हाँ जी, हाँ जी।
गुप्ता जी,
सर,
मैं होता
जहां
ही नहीं।
तक अनलिस्टेड सिक्योरिटीज है वहां पर शायद 12.5% नहीं है। उसमें आपको 1/4/2000, क्योंकि आज डॉक्टर गिरीश आहूजा जो कह रहे थे,
हाँ जी,
उसमें यह था कि जहां तक 1/4/2001 की वैल्यू ली जाएगी,
वो तो
क्योंकि
सेम
वो 112A में फॉल नहीं करेंगे।
राइट।
1/4/2001 से पहले की जो सिक्योरिटीज है उस पे एसटीटी पेड नहीं होना चाहिए, तो वो 112 या 112A में फॉल नहीं करेगा, तो 1/4/2001 की वैल्यू सब्स्टिट्यूट होगी और इंडेक्स नहीं अप्लाई होगा।
मैम ये दोनों चीजें, सॉरी गुप्ता मैम, इसमें कोई डाउट नहीं है कि 1/4/2001 वाला गुप्ता जी नियम चेंज नहीं हुआ, और वो जो आप दूसरी बात
हाँ,
बोल
वो
रहे हैं मैम,
चेंज नहीं
वो
हुआ
दूसरी
है।
वाली बात भी में भी कोई इफेक्ट नहीं है। यहाँ पॉइंट ये कि उन्होंने क्लियर कट लॉ में लिखा है, जगह जगह आप देखेंगे कि दैट एंटायर गुप्ता जी मैम
बिल्कुल यू आर राइट। मैडम को कुछ कंफ्यूजन है। मैडम जो है सारा ऑन द बोर्ड फॉर एवरीथिंग रेट इज 12.5%. देयर इज नो हायर रेट फॉर लॉन्ग टर्म कैपिटल गेन.
Gupta, may I add something?
प्लीज।
So, ऐसा कि फॉर एग्जाम्पल 10 लाख की एक वैल्यू थी 2001 की, इंडेक्सिंग करके 40 लाख हो रही थी,
राइट,
और इसके बेसिस पे कैपिटल गेन बन रहा था 1,90,00,000।
ओके,
और अब विदाउट इंडेक्सिंग बन रहा है 2,30,00,000। अब ये जो एडवांटेज था कि एक प्रॉपर्टी जो 2 करोड़ का कैपिटल गेन कम होगा तो एक बाई 2 प्रॉपर्टीज, वो एडवांटेज भी लॉस्ट हो गया।
वो तो मैथ्स के ऊपर होगा कि
नहीं, अगर कैपिटल गेन देना होगा तो इसमें तुम्हें एडवांटेज हो जाएगा कि 20% 12.5% हो गया। पर
अगर एक मकान
इन्वेस्ट
बेच
करना
के
है,
दो
इन्वेस्टमेंट
खरीदने
करना है तो इन्वेस्टमेंट बढ़ गई तुम्हारी।
थे, नहीं, एक मकान बेच के 2 खरीदने थे जहाँ कैपिटल गेन 2 करोड़ से नीचे था।
हाँ
अब वो क्योंकि इंडेक्सिंग अलाउड नहीं है तो कैपिटल गेन 2 करोड़ से ऊपर निकल गया।
राकेश
ये
है
तो
पॉइंट।
ये तो सब इश्यूज
सर
रहते
का वजन,
रहेंगे।
शिवानी जी आप
चलो,
बड़े हैं, सर का कल भी बात हो
नहीं,
रही
राकेश
है,
जी,
सर का वजन तो पाव
राकेश
में
है
आएगा
पॉइंट
ही।
इन दैट।
हाँ, सर का
चलो
वजन
कपिल, लेट अस प्रोसीड फर्दर।
Please, sir. Section 50AA is a third chain, sir. Unlisted debentures and bonds will
Yes.
be, they have made it included in section 50AA. They will
Right.
be taxed at the, मतलब उसको short term capital applicable rate लगेगा, जो भी applicable rate है,
That will deem to be short term capital gain and normal rate.
and normal rate.
Right. Yes.
Fourth change is very important, sir. 47 clause 3.
Yes.
Earlier, it was a position taken by various corporates also that
Correct,
if they make gifts, etc., some corporates or firms, that will also be immunized as transfer under section 47.
Correct.
But they have said that it is not right. Only individual and HUF can transfer under gift, will, or irrevocable trust, which will be treated as not transfer. Otherwise, if anybody will make a gift, etc., they say it is not exempt as transfer. So that amendment they have made, I believe it is made from prospective effect only, sir.
Right.
It is not a retrospective amendment. So these are the 4 set of changes which are in capital gains, Gupta ji. Now I take up another area to which you are also a master, charitable trust. Although you are master of everything, but this charitable trust, I know, and charitable trust also is a subject, sir, which, ma'am, I read sometimes, na, I get so confused with the section 1023 capital C 12A. Kyani ji, I never understand what is where we start, where we end. Now take an example, ma'am. They make a 1023 capital C. They inserted 24th proviso.
Yes.
In this finance bill, there is a proviso inserted in section 1023C, which is numbered as 24th.
So you will get rid of this. Get rid of this. All this 23C will go.
So they say that in this amendment in 1023C, they want to merge 1023C into 12A. So they have stated that we are starting with like this: कि no application, Gupta ji, will be approved after 1st October 2024 in 1023C. Meaning thereby, if approval has to be granted in 1023C and new application is filed after 1st October 24, that will not be entertained and considered.
Yes.
But if something is to be given otherwise in 1023C, like state-sponsored institution or people who are having some less than turnover, I believe they are not affected from this. Because they say in the proviso which is added is provided also that no approval under the second proviso shall be granted in relation to any application. Now application is made for something else, 1023C3 AD. Application is not made for other like state sponsored institutions where government is sponsoring, or where the income or the receipts of the educational institution is less than a particular turnover, Gupta ji. I believe whether it should not be impacted by this amendment, in my opinion. It is approval wala point only. They have said for where approval has to be granted, application after 1st October 24 will not be considered.
Right. Clauses 4, 5, 6, they have been referred to.
और जिनके पास दोनों की रजिस्ट्रेशन है, उनका क्या होगा?
भाई साहब रजिस्ट्रेशन दोनों क्या कह रहे हो प्रकाश? किसके बाद तो दोनों रजिस्ट्रेशन हो ही नहीं सकते आपके पास. भूल जाओ.
लास्ट ईयर अमेंडमेंट
आप बाइगैमी कर सकते, वो कह रहे हैं.
21 के बाद दोनों हो ही नहीं सकते थे.
बिल्कुल.
I am sorry, Gupta ji. They are saying ultimately you have to switch over from 1023C. They have said. तब जितना मैं समझ पाए, if I am not wrong, Gupta ji will correct me, you may correct me, कि they say कि if you are enjoying earlier 1023C for a particular period, you will be allowed that. After that, you can also come in the house of 12A.
5 साल तक का रिकॉग्निशन मिला था आपको.
Right.
जो जब तक वो पीरियड कंटिन्यू रहेगा तब तक you can claim under 1023C. After that, you have to file the new application for renewal, which will be under section 12B.
Right. And whatever applications have been filed, Gupta ji, earlier, they will be considered according to the law prior to Finance Bill 24, which are already filed prior to 1st October 24.
Applications pending or up to prior to 1st October 2024 will be considered under the respective process.
Under the respective process. So they want to, I believe 1023C has to be taken to this. This is the sense of this amendment.
Right.
Two important amendments, sir, which I noted, Gupta ji, you may further add if I left something. Two important things which I figured out, sir, is one is this power given to the commissioner to condone the delay in filing of application in section 12 capital.
Yes.
I believe it is a very positive change and benevolent change, right-minded change, that they are giving this, sorry, I don't know, this is come, sorry. Sorry, sir.
Kapil, you are audible.
Yes, ma'am. Sorry.
Yes, please carry on.
So section 12A, ma'am, they are given the power to the commissioner that if an application is filed with some delay, then they, without any outer period, they say if commissioner finds the delay is with reasonable cause, then he may condone the delay. The effect of this is this: if he would not, I mean, then they have rightly realized later delayed application of file, etc., can result in Gupta ji accredited tax in chapter 12.
Yes.
Right.
So now this power giving will save them from that draconian implication.
Right. That's right.
So this 12A, the change is in section 12 capital A, subsection 1, clause AC. There is a proviso added that condonation can be done. Third important change which I find is very also important is, and which may also give some motivation to the charitable trust, ma'am. They say that there can be merger of charitable, similar and same charitable trust without attracting any adverse implication. So the change, they have brought a new section, Gupta ji, 12 capital AC.
Yes, that's
that they have said that if a charitable trust merges into the other charitable trust, which is registered trust, and which have same similar objects, and which follows the prescribed conditions, which will be prescribed, then it will not attract the section 12, chapter 12BB accredited tax.
I think this position, even though it is better now, they have clarified it, but I think this position has been always in the past also. When you transfer all your assets, that section accredited wala, that also provides. If you transfer to any other trust, which is having same objects, then there is no adverse influence.
But as you rightly said, I also thought so. Now if you, with due respect, you may correct me.
Yes,
they have added 3 conditions, sir. That objects of the other trust should be same and similar, same word and similar word. Second, they say it should be registered body. Third point is very interesting, sir. That there will be some conditions which will be prescribed will have to be followed in this merger.
Let us see.
Yes. No.
मेरे ख्याल से ये प्रोविजन पहले से सर वो एक्रीडेट सेक्शन में है सर.
उसमें है, उसमें ऑलरेडी था, उसमें ऑलरेडी था.
पर वो प्रकाश सिन्हा जी इनेबलिंग प्रोविजन नहीं था हमारी लैंग्वेज में, मैं करेक्ट बोलूं तो ये इनेबलिंग प्रोविजन है.
So that is good. They have brought this specific provision for.
Anyhow, sir, these are the
merger has to happen through a court scheme.
No. This can be your own scheme and assets.
Yes, sir.
You will transfer all the assets and take the approval.
Okay.
Right.
So now Gupta ji, I come to the third part of my change is TDS provisions. See, again, this is a sections and chapter 17B. Ma'am, we have qualified right from my qualification days of CA 2004 till 2024, 20 years I have qualified. But till date, as in charities, I never understand what is the sense of increasing TDS family year by year with new family members. That every time this chapter has become so densely populated that every time you have a section where a new TDS and TCS requirement.
Correct. Every time they are increasing.
And see, from a perspective of it may be a perspective of revenue that it is good that they are making it advanced collection of tax, etc. But from perspective of deductor, sometimes it becomes a challenging scenario that how to grapple with all these TDS provisions which are sometimes one is overlapping into other and other is overlapping into other. So you don't know which to apply. So example, they this time say, ma'am, where 194 capital C overlaps with 194 capital J, then 194J will have Ganesh's Sthan, Pratham Sthan, and 194CL has second Sthan. So, I don't know. The lawmaker, Srivastava Sahib is lightly smiling. So,
Kapil, I think the objective is very clear. The widening of tax base. You see, we talk about a population of 135 crores, and then what is the number of taxpayers? So, somewhere they have to, at international level also, they have to just justify that, okay, we are trying to bring in more people under the tax net. Though it may not affect the revenue as such. In fact, whatever tax is deducted in most of the cases, this will get adjusted against the advance tax. So it may not affect the tax base as such, but the quantum of tax, but tax base increases.
Point taken, sir. I take Gupta ji now. See, first change is point taken, sir. Section 192, subsection 2B. Srivastava sir, your point is well taken. 192, subsection 2, clause B, capital B. They say in case of people who are employees and TDS has to be deducted under 192, Gupta ji. They give them some facility now that in whatever TDS and TCS for the same financial year, if it is deducted by somebody else, they can intimate to their employer. And their employer will, ma'am, factor it into their TDS calculation.
Yes.
Right.
So that is under section 2B.
I'll give you a live example. In my own family, it happened. My son last year purchased a car.
Example.
Now there is a TCS. The benefit of the refund of the TCS will be only after filing return.
Srivastava ji has always a beautiful cake points.
Okay.
So Srivastava ji, kindly bear, otherwise we will leave something, please. आप मालिक हैं सर, वैसे मैं इसलिए बोल रहा हूँ सबसेक्शन 2
वो इसको नहीं, this is just 192 वाला जो भी इन्होंने किया है, it is just to give some benefit to people.
Right. That is what I'm saying, sir. This is a positive change. They are now allowing employer they can intimate to their the employee can intimate to their employer all the TDS and TCS which will be factored while making TDS, so that there is no fund impact and genuine impact on the cash flow of the employee.
The problem will only arise where the purchases are made in the month of March.
Srivastava, let us proceed further.
Sir, we will leave because TDS changes are many. 192 subsection 2B you can note. Second change, Gupta ji, is in 194 capital C. They insert a clarification in 194 capital C. They say wherever 194J will be applicable subsection 1, then 194J1 will apply, ma'am, will have supremacy over 194 capital C. Third change is in these sections where TDS rate has been reduced from 5% to 2%. Gupta ji, I have picked three relevant sections which are useful, which are important day to day. 194 capital H, 194 IB, and 194 M. 194H we all know, ma'am, commission brokerage wala section hai. 194 IB and 194 M were latestly introduced in the previous bills where individual was supposed to deduct TDS on personal expenditure also. So that rate has been, Gupta ji, rationalized from 5% to 2%.
That's it.
The sales
so this is 194H, 194 IB and 194 capital
made against the transit goods.
Volleyball sir, apna
please.
So now, Gupta ji, 194 capital O mein the change has been made from for the TDS or e-commerce transactions from 1% to 0.1%. So these are the rate changes. They say that we are making some rate changes to give relaxation to the people where 5% to 2% have been made. I have pointed out 3 important sections. And in 194 O, ma'am, they have reduced from 1% to 0.1%. Now there are 2-3 more important changes in TDS regime. 194 capital IA. Now in 194 IA they say, Gupta ji, if there are multiple transfers, ma'am, now 194 IA deals with TDS on immovable property sale purchase.
Yes.
If there are more than one transferor and more than one transferee, they say aggregate will be taken. It is qua property now. If the threshold amount.
Yes.
All transferors and all transferee, Gupta ji, included.
That's it. That's it.
Am I right, sir? That
Yes,
provision
Yes,
will be
yes.
Very right.
So 194 IA, they have added the aggregation for the threshold. 194 T is the new entrant in the TDS family, where they say that partnership firms paying, and this is a joke, man, with due respect. It's a cruel joke. When they give threshold of 20,000 and they recommend TDS rate of 10%, no, that is a point apart. But 20,000 threshold, and Gupta ji, then recommending that all partnership firms will now deduct TDS on salary, etc., etc. So definitely there is no problem, ma'am. If you start saying TDS as Srivastava Sahab was saying that widening of tax base, this can have some other good objective also. But this change, as far as I am concerned, I can't understand, Gupta ji, that what is the sense of that 20,000 rupees, as people are asking. What is the fun of this 20,000 rupees?
Not only 20,000, TDS principally itself is wrong. This is a partnership, and partners are not legally are not two separate entities, though for the purpose of income tax they are.
They are. So
it is the payment to yourself.
And again, ma'am, why I was saying, Premlata ma'am, this TDS you will better appreciate, Gupta ji, that all these changes now, when something is deducted tax, as we have observed in litigation practice, that when you have faceless assessment and subsequent assessment and reconciliation being made of the TDS vis-a-vis your final return income, then it creates a lot of painful thing, Gupta ji. It's not easy always at the time. So anyhow, 194 capital T is the new TDS provision which will be prospectively applicable.
कपिल, इसमें एक प्रॉब्लम और भी आएगी, आज बहुत डिस्कस हुआ था इस पे कि जब पार्टनर विड्रॉल करता है मंथली और एट एनी पॉइंट ऑफ टाइम, तो क्या डिपार्टमेंट ये कह सकता है कि सैलरी हैज बीन विड्रॉन बाय द एसएससी, नो टीडीएस हैज बीन डिडक्टेड देयर फ्रॉम? ये इश्यू क्रॉप अप हो सकता है, बिकॉज मोस्ट प्रोबेबली क्या होता है कि एट द एंड ऑफ द ईयर वी आर क्रेडिटिंग द सैलरी. Most of the firm are crediting salary at the end of the year. Even profit accrue at the end of the year. So if any withdrawal is made during the year, can department say that this is the withdrawal of salary?
Definitely that dispute will be there.
This will be litigation point.
तो क्या हर withdrawal पे TDS काटना पड़ेगा?
Yes.
This is the issue.
Right. क्योंकि नॉर्मल विड्रॉल जो है वो तो एज ए रेम्युनरेशन या सैलरी के अगेंस्ट एट्रीब्यूटेबल होगा.
समझिए कि पार्टनर अपने हाउसहोल्ड विड्रॉल भी कर सकता है. जैसे पर मंथ पार्टनर की और कोई इनकम नहीं है, पार्टनरशिप फर्म से इनकम है, तो वो अपना हाउसहोल्ड विड्रॉल भी पर मंथ वो समझिए कि 1 लाख रुपए निकालता है, तो क्या वो सैलरी विड्रॉल मानी जाएगी?
Ma'am, if I see in chartered accountant, sorry, if Gupta ji will correct me. See, ma'am, in chartered accounting sense, if I credit to the partner's account these words which they have written in the law, salary, remuneration, commission, bonus, or interest, they are for TDS. Now, again, see, withdrawal is a different act. Withdrawal comes in debit side of that account. Now, if I credit this to his capital account, they are saying I have to deduct TDS, Gupta ji, if I am not wrong.
Or payment thereof, whichever is earlier.
इसी कपिल इशू ये है कि जैसे मैडम कह रही हैं कि बहुत सारे केसेस में क्या होता है कि ईयर एंड पे यहाँ पे कोई लॉ नहीं है कि मुझे सैलरी हर महीने देनी है.
राइट, आप सही कह रहे हैं.
या बोनस देना है, या देयर इज लॉ डजंट प्रोवाइड दैट.
वो जनरल विड्रॉल करता है.
लॉ प्रोवाइड्स द ओवरऑल लिमिट दैट आई कैन पे अप टू 90% of rupees 6 lakhs now and balance 60% at the, so that amount can be determined only at the year end and can be paid at the year end. So that amount can be credited to at the year end, but during the year itself, every month, he may withdraw some amount.
मैम यहाँ तो जो बड़ों ने सिखाया है ना, सॉरी यहाँ तो प्रिंसिपल, हाँ सॉरी,
इस चीज को रोकने के लिए
सर कुछ लाइट थ्रो करेंगे इससे.
To avoid this anomaly or to avoid this hardship, we have to maintain 2 accounts, current account and the capital account. Capital account से विड्रॉ कीजिए, कोई झंझट नहीं है. करंट अकाउंट से विड्रॉ कीजिए, जहाँ सैलरी क्रेडिट कर रहे हैं वहाँ एक प्रॉब्लम आ सकती है. दैट कैन बी टैकल्ड.
गुड सजेशन सिंह.
सर पुरोहित साहब कुछ कहना चाह रहे थे सर?
हाँ जी सर।
Sir, if I am making withdrawal from my capital,
जी जी.
there will be a TDS.
There will not be TDS when you are withdrawing capital.
Department say that the withdrawal is in the nature of salary.
Yes, yes.
That is the problem, sir.
Sir,
In which compartment you allocate it? You allocate it
Yes.
against. See, right to allocate is with the department, or right to allocate is with the taxpayer.
The right to allocate is with the taxpayer. Because suppose I have my capital account in the firm and their certain amount is already deposited. So who can say that I am withdrawing from that or I am withdrawing from profit?
प्रो साहब आप तो बड़े, मेरे कहना ये कि सर जो इन्होंने गुप्ता जी ने कहा ना कि इसमें तो फिर वही प्रिंसिपल लगाना पड़ेगा, एक्स अबंडेंट डाइक कौटिला, वेयर एवर यू आर इन डाउट यू डिडक्ट टीडीएस.
एक बात और ना, टीडीएस में डिफॉल्ट भी हो जाएगा.
हाँ.
Profit of it
बात होगा फिर सितंबर के बाद में.
the end of the accounting year. And at that time, your salary is determined how much salary is payable as per section 43B.
हाँ.
40 is small.
Anyhow, Gupta ji, can I?
Can't,
Sir, please.
or if you want to more specific, then you can have one current account and you can have one capital account. So if you make, even if you are making withdrawal from current account, then this point may arise that you are withdrawing salary.
Right, sir. Right, sir.
Because the earlier provision was, the interest was provided that there can be no compound interest. That is why we advise the assessees to have a current account, so that the whatever withdrawals were made were in the current account and interest is paid on your capital, fixed capital.
सर, पर मोस्ट ऑफ द पार्टनर दो अकाउंट मेंटेन करते हैं, वन इज द फिक्स्ड एंड अनदर इज द करंट. तो फिक्स्ड में क्या होता है कि 10,000 डाला और 100 रुपए की स्टाम्प पेपर पे पार्टनरशिप डीड लिख दी. और जो 1-1 लाख रुपए
सॉरी मैम, रहने दीजिए उस पॉइंट को.
तो सर आपको पार्टनरशिप डीड दोबारा लिखनी पड़ेगी, फिक्स कैपिटल बढ़ जाएगी.
Department
स्टाम्प पेपर बड़ा यूज करना
problem,
पड़ेगा.
Gupta ji, with all these TDS provisions now they give a good sense to it. Now by the time it is to be applied, there comes so much of burden sense on this.
That's true.
Anyhow, sir, I'm going forward, sorry, with your permission. 197 section for low TDS, ma'am, they have included in section 197, 194Q. That although this section itself is very much painful, but to give some relief, they say people can apply under 197 for low TDS, qua 194 capital Q also. 198 changes like this, Gupta ji, the people to whom the some tax has been paid abroad and they are claiming credit in India, but they are not showing as income in India. That is the deemed income change which they have made in section 198. That tax which has been paid outside India and deducted and credit claimed in India, but it is while grossing up in the income portion, gross total income, they have not considered it. So they say it will be deemed to be received as far as section 198 is concerned. Am I right, sir?
Yes, you are right, perfectly right. What the government is saying is also right. I don't know whether there can be any cases that tax is not shown, income is only shown that of tax.
Section 199
And whereas claim is made for TDS.
Tax is deducted, that is.
But ma'am, they Gupta ji, they have said in memorandum, they have found some cases.
They have said.
Yes,
so that is what we have to believe. Whatever they are saying, they may be right.
King is right, sir. Section 200. Correction statement. Till what time correction statement can be filed by the deductor? They have capped it till 6 years from the end of the financial year, sir. In section 200, the change is in section 200. By what time correction statement can be filed by the deductor, so that there is healthy balancing between deductor, Prohit and deductee. So that is the change which they have made in section 200. So that deductee can also not have problem and correction statement cannot be filed limitless.
But 6 years period in today's context has no meaning. Your assessments will be finalized much before that.
Right, Gupta ji,
what will you do?
जैसे पहले वाले में कहा,
correction can also not be done by the department.
I also was wondering what is the sense of keeping it in 6 years?
There is I don't know what.
And 200 capital A subsection 3, the change is like this, 200 capital A subsection 3. They say that board can make scheme of processing of statements by non-deductor also. When various non-deductors file some statements to the income tax department, that can also be processed. CBDT can notify the scheme for the same in section 200 capital A subsection 3. In section 201, Gupta ji, there is a very important change. By what time TDS default proceedings can be launched on the deductor, and likewise in TCS also. they have capped it till 6 years. Earlier, it was 7 years for all resident deductee, non-resident deductee proceedings. Everywhere they have included in section 201.
For non-resident assessees, pehle there was no time limit. That
Yes,
is the
now
version
they
of the department.
yes.
Now it will be 6 years for both.
For both, yes. Although courts have read a reasonable time limit in the
Yeah, that's true. I'm aware.
So 206C, now people see, Gupta ji, they say in memorandum that TCS will now be done on luxury goods also. In memorandum, the word used is luxury goods.
Luxury goods.
In this section, they say it will be notified goods.
Notified.
If I'm not wrong, in section, they have never used the word luxury goods.
Yeah, that's true.
So, although in memorandum, they have emphasized, Purohit Saab, this new TCS, which is entry into the TCS family, is that person who will purchase luxury goods of amount, they have capped the amount of 10 lakh rupees, then TCS will be there. The criteria which they have spelled out in memorandum, the horse in the law, they say that it will be qua luxury goods. Now, firstly, luxury good definition is itself not there in the bill. And secondly, to say something is luxury or not, it's again a very different thing, Gupta ji. What can be notified in name of luxury goods?
Yeah, जो notify कर दें वो luxury हो जाएगा.
वो luxury हो जाएगा. That is the message.
Okay. 10 लाख से ज्यादा की जो चीज खरीदोगे तुम.
When my friend Purohit Saab was saying, I was wondering what is the sense of this change. He said, Mr. Goel, you are a litigation lawyer. You do so much 148 practice. It is for your betterment. Many people will get 148 notice when the TCS will be done in 206. As you are smiling, Purohit Saab, I was also smiling.
This is for our benefit.
Sorry?
This provision is for our benefit.
Yes, that is one way of looking at it, sir. In 206C, Gupta ji, they have made some more changes also, that in 206 capital C, they have aligned it with TDS, like time limit, by what time TCS default proceedings can be done. As in TDS, the TCS also, they have kept the 6-year time limit. Now, some for lower tax collection at source, they have also now included section 206 capital C subsection 1H. For lower TCS, section 206 capital C 1H has been included qua lower TCS, as they have done in addition in 197. Here they have done in 206 capital C 1C. What can be subject matter of lower TCS? They have expanded the scope of lower TCS. One important change, Gupta ji, will be they have given special power to CBDT in section 206 capital C subsection 12, that CBDT can notify some persons and transactions which will be out of ambit of TCS. That is the delegated power given to CBDT to notify the people and transactions under section 206 capital C subsection 12. Next change in TCS are two other changes, sir. One is section 276 capital B is a change which has been attracting lot of attention, positive attention. That Gupta ji, lot of TDS prosecutions have been launched in the past. And people who have deducted Purohit Saab TDS but failed to deposit the same in the time, they have given one relaxation now, Jain Saab, that they say that people who will deduct TDS and are depositing till the time available for filing the return of that quarter, then no prosecution will be launched under section 276 capital B.
Correct.
Many people ask me, Mr. Goel, can it be taken for the benefit for the previous cases which are going on, Gupta ji?
No, the law at the
I have a different feeling, sorry. Why? I will tell you. I read one decision of Honorable Supreme Court by Justice P.S. Narasimhan. It is a very interesting order, but you can note that down, Gupta ji. It's a landmark order, one of the very few orders Supreme Court has penned down like that. Pernod Ricard is a Supreme Court order authored by Justice Narasimha, where the issue was this, there was reduction of penalty subsequently in a law, MP law, some penalty. Now, question before Supreme Court was this, whether benefit of reduced penalty can be given to past cases also. Supreme Court says if the sense of the law is this, amendment and the change is this, reduction is to give benefit to the people at large, then the same benefit can be given to the previous cases also. So I don't know. Anyhow, this is a change which is a welcome change. Many people try it to apply to the past cases also. Maybe they are successful or not, depend upon the judge and the court concerned. So 276 capital B is some relaxation, decriminalization has been done. And in the budget speech, Gupta ji, ma'am has also stated, FM ma'am, that they will bring one SOP for TDS default and fresh compounding guidelines. One can note it down. They have said in budget speech that new SOP of TDS defaults and compounding guidelines will be announced. If I'm not wrong, in the budget speech, it is there. Last change of TDS is section 271H. The window which was there to come out of penalty in 271 capital H, which was 1 year earlier, Modi Sahab, which is now reduced to 1 month. So this is the package of changes, Gupta ji, regarding TDS. Lot of changes are there. I have tried to discuss. Almost, if anything is left, Gupta ji, you can also shed light, sir.
Particularly the interest increase from 1% to 1.5%.
That TCS?
Yes. TCS, yes. In case of TCS,
aligned
yes.
with TDS.
TDS was already there. This has
Yes.
been aligned in this case of TCS.
Sinha ji, you want to say something?
No. I was just saying one thing. जो आपने कहा ना वो पेनाल्टी वाला इशू के ऊपर, तो आपने नरसिम्हन का जजमेंट बोला ना, अभी और भी मैटर चल रही है जहां पर अभी न्यू आईपीसी में बहुत जगह सेंटेंस को रिड्यूस कर दिया गया है. तो व्हाट विल हैपन, जो लोग पहले से सेंटेंस जो है उनके ऊपर अधिक सजा दिया गया है.
नहीं आता सिन्हा जी, मुझे तो इनकम टैक्स ही नहीं आता है. आप मेरे से सही सवाल पूछ रहे हैं गलत आदमी से.
नहीं, जस्ट मैं उनके पेनाल्टी वहां भी आ रही है, इशू आ रही है कि वहां भी सेंटेंस क्या होगा.
सर पर्सनल रिकॉर्ड पढ़ ले, पर्सनल रिकॉर्ड से आपका काम चलता है तो चला ले.
हाँ,
अब बिजनेस साइड पे आ रहा हूँ गुप्ता जी. मैं लास्ट में लूंगा वो बिजनेस रीअसेसमेंट, अपना फेवरेट सेक्शन रीअसेसमेंट और सेल्फ असेसमेंट उसके एंड में लूंगा.
ठीक है.
बिजनेस हेड ले रहा हूँ सर मैं. आप बिजनेस हेड के चेंजेस सर, there are 4 critical changes, sir. First change is section 28. They say income from letting of residential house. Now I don't know. See, in the somebody can have a different feeling. In the grudge to have revenue, you say that any person who is letting out residential house will now be will never be classified as income from business income. It will always be income from house property. It is a default rule and irrebuttable rule. So the amendment has been made in section 28. Explanation number 3 has been inserted, saying that income from letting of residential house, the word used is residential house, will be taxable under the head house property only, not under the head business income. Am I right, Gupta ji?
Does it mean that commercial properties can be claimed under profits and gains?
Sir, by exclusion, they are not talking about.
You see, always the thinking has been that renting of the all properties, whether residential or commercial, will be considered under the head income from house property.
Sure.
Only in a very limited or exceptional cases one can say it is my business and therefore chargeable. Supreme Court has also taken always that view.
Right.
Chargeable under the head income from house property. So what do they want to say about why this provision or amendment has been done?
Right. This is a very common perspective which you are adding. You mean to say कि Kapil उसके अंदर if there is a commercial property being let out, so now they want to say that it will be business income only.
So
can one draw inference? You want to draw inference from this?
Yes. So that is I have not been able to understand the background of this provision.
The background of this amendment which they have stated in memorandum is this. That is very interesting to note. I am not saying jocular. Gupta ji, that's not.
शायद commercial में कहीं dispute हो सकता है, but residential में तो dispute का मतलब ही नहीं है.
They have what they have suggested. They have given a background sense. The rationale given in the memorandum is that people who are claiming residential house property, residential house letting income in business income, they are suppressing their income or they are claiming undue benefit from the government.
That wrong है. आज की डेट में 30% जो एडवांटेज वहां मिलता है नेशनल इलेक्शन को, दैट इज बेनिफिशियल. मतलब either they could say in case of a builders or the persons engaged in the property development, they may be specified.
But there is one more question, Gupta ji. I just deviate. Kindly enlighten. What is your sense on this? See, there are various properties which are though classified in the records of government as residential house, but which are utilized for commercial purposes. Now, the clause says residential house. It does not. Now, it is utilization test or it is the nature label test.
We have to go as per the nature, as per government.
एक इश्यू और क्रॉप अप होगा. कपिल, what I want to say that in the case of builders, a building is constructed, whatever flats, residential flats, which remains in the hand of the builder, and those are rented out by the builder, whether that income would be the income from house property or business income. Because earlier in the case of Bansal properties and Chennai properties, in all those, because that is stock in hand in the hand of builder. So
Madam, based on the Bansal properties, they amended the provisions section 23.
Already that amendment has been.
They amended the provision section 23, saying that in case stock and trade also
is kept for
even if it is not. even if it is not let out,
23 में amendment
this
था
is deemed to
उसमें.
be property under that and
So this
notional value.
amendment is more dangerous now, ma'am.
So what? Where is the requirement of this amendment when everything was already treated under Section 23 as the income from house property?
Madam, that is what I was saying. That I have not been able
Then
to
what was the need?
understand the rationale.
Sir,
साहब बता सकते हैं rationale.
इसमें एक
सर मैं एक क्वेश्चन पूछना चाहता हूँ.
मैं just
Hello.
see, there are a number of large public sector undertakings which have residential colonies. Now, in respect of those large public sector undertakings, now what the staff quarters let out to the member, to the staff, that will get triggered. That will get triggered under the income from house property now. If I think it from that angle, that housing colonies of large public sector undertakings, till now it will definitely have an impact on them.
वो रेजिडेंशियल हाउस है श्रीवास्तव साहब, ये क्या है?
नहीं, रेजिडेंशियल हाउस है, रेजिडेंशियल कॉलोनीज होती है ना. अब स्टाफ क्वार्टर्स दें. Wherever there people have staff quarters. Companies have staff quarters.
गुप्ता जी, ये तो सब लिटिगेशन बढ़ाने का काम है.
नहीं देखिए, ऐसा जहाँ तक स्टाफ क्वार्टर्स का जहाँ तक सवाल है, वो अभी तक मतलब जो है हो सकता है वो माइंड में, पर वो कहा नहीं ना इन्होंने. They should have said so if they wanted in that way. तो ये बात ठीक है अनिल जो कह रहे हैं. हमारा भी मतलब डीसीएम लिमिटेड में आई बीन डीलिंग विद दिस सॉर्ट ऑफ मैटर्स. ये जो स्टाफ क्वार्टर्स होते हैं, दे आर बिजनेस एसेट्स. उनपे डेप्रिसिएशन भी क्लेम करा जाता है, सब कुछ होता है. और उसमें नॉमिनल या तो फ्री ऑफ कॉस्ट दिए जाते हैं या नॉमिनल 10-20 दिए जाते हैं. तो वो जो है उनमें मेरा जो हम डीसीएम में जो करा करते थे, जो भी उसकी रेजिडेंशियल प्रॉपर्टीज में भी इफ सम प्रॉपर्टी हैज बीन गिवन टू एन आउटसाइडर, से हम स्कूल को दिया गया है या पोस्ट ऑफिस को दिया था या बैंक को दिया था,
बैंक को है,
या उस टाइम एक्साइज डिपार्टमेंट को दिया करते थे, वो हम जो इनकम फ्रॉम हाउस प्रॉपर्टी में लेते थे. और बाकी रेजिडेंशियल जो होता था एम्प्लॉइज का, वो इनकम फ्रॉम बिजनेस में, क्योंकि सारे उसके एक्सपेंसेस जो हैं नॉर्मल बिजनेस एक्सपेंडिचर में जाते हैं, और नॉर्मल उसकी इनकम जो है, दैट इज व्हाट हैज बीन. इम्प्लीकेशन क्या होगा, आई एम नॉट एबल टू अंडरस्टैंड.
नहीं, अब अपैरेंटली अभी अगर आप कहते हैं कि इट विल बी इनकम फ्रॉम हाउस
जी, कपिल जी एंड रेस्पेक्टेड कलीग्स, may I most humbly request you to kindly keep your questions and observations pending.
Sir, sorry.
Let Sri Kapil Goel ji complete his deliberation, and then we can come up with our observations.
Okay, sir.
I hope you will kindly.
Point taken, sir.
Very right.
Point taken. You are rightly guiding us, sir. After Section 28, sir, Section 36, Clause 1, Clause 5A, the contribution by the employers in the other sectors to NPS from 10% to 14% of the salary. The earlier cap was 10%, Gupta ji, in Section 36(1) Clause 5A, 4A. Now it has been increased from 10% to 14%. The next change is in Section 40, which is very important change. Some relaxing change. They have recognized that limit of partnership remuneration was fixed long back. Section 40, Clause B, Clause 5. They say, Jain Saab, in the amount which was 3 lakh rupees in the first slab, they have increased the slab of 3 lakhs to 6 lakh, Gupta ji. And correspondingly, the amount which was could be given 1.5 lakh, they have increased it to 3 lakhs. So now by this, the eligibility of the partnership firm to give more remuneration under the law of Section 40, Clause B, Clause 5 has been there. And it is a welcome change to my mind. The next important change, Jain Saab, is in Section 44BBC. They want foreign shipping companies to come in India and have cruise operations here. So they have brought a presumptive scheme, Gupta ji, in Section 44BBC, that the non-resident companies, they are inviting them to come India and do cruise operations in domestic sector. So they have brought a presumptive scheme for them in Section 44BBC to give incentives to them for foreign companies only for domestic, this cruise operations, domestic cruise operations in India, sir. And the rate has been fixed in that Section 44BBC, sir. So as far as this business side is concerned, Gupta ji, this changes ends here. Now I come to the most trickies and most troubles, what do you say, most, what do you say, Jain Saab is already smiling. That reassessment and search assessment. I don't know, sir. Gupta ji, at one time in 1995 when block assessment came, and we are in 2024, this block assessment is reincarnated by Chapter 14B. Now, the reassessment and research assessment, Jain Saab, was latestly changed in 2021. We are 3 years just ago. Now again, everything is being again recasted. In as far as this reassessment change and search assessment change goes, Gupta ji, I first take reassessment. 4 sections they have overhauled in reassessment. Section 148, Section 148 capital A, Section 149, Section 151, and 5th one, Section 152. Now, this goes like this, Jain Saab. They put a sunset clause also in Section 1. I go reverse. Section 152, they insert 2 subsections, subsection 3 and subsection 4 in Section 152. They say, for the reassessment notices which will come till 1st September 2024, the law will apply, Gupta ji, prior to amendment by Finance Act 2024. That is the law amended by 21 law. I repeat, for the notices of the reassessment which will be issued till 1st September 2024, the law which will apply and govern Jain Saab will be the law prior to amendment by Finance Bill 2024, Finance Act 2024. So the sunset clause is put in Section 153 to 152 subsection 3 and subsection 4. And likewise, they say for the searches which will happen after 1st September 2024, definitely new block assessment will apply. But for the searches which will happen prior to 1st September 2024, Gupta ji, the provisions of Income Tax Act prior to amendment by Finance Act 2024 will apply. So Section 152 gives us 2 sunset clauses. I just was wondering, Gupta ji, you will correct me on a very larger issue. This, when 2021 change take place, Jain Saab, there was no sunset clause like this. When they have made this change, it's very interesting to analyze it in a comprehensive sense. Now they are bringing the sunset clause when they are rehauling in 2024 in 152 subsection 3 and subsection 4. So can one draw an analogy, Gupta ji, when this was missing in 2021 law? Can it help taxpayers that old 148 proceeding prior to 2021 will destroy, since there was no saving clause as now has been brought in section 152 subsection 3 and subsection 4? So that's a question mark. Now, if I go further, apart from the sunset clause change 152, they have kept the date of 1st September 24. Now, the change which has been made in 149 has to be appreciated. They have brought 2 subsections, sir. 149 subsection 1, 149 subsection 2. 149.1 says, qua notice under 148, the criteria will be like this, when 148 notice will be issued. In 149.2, Jain Saab, they say, qua 148 capital A show cause, the criteria will be like this. I don't know, Gupta ji, in my extreme sense, when I compared 149 subsection 1 and 149 subsection 2, I can't reconcile myself. You will reconcile. That what is the sense of saying that in 149 subsection 2, when the show cause notice will be issued under 148A, the criteria will be different. And when 148 notice will be issued, final 148 notice will be issued, the criteria will be different. I don't know how it will happen and at what stage you will see the criteria of 149.1. This is a very serious thing, because in 149.2, what they say, Gupta ji, 149 subsection 2, they say when 148A notice will come, only information criteria will apply, information suggesting escapement of income, and post 3 years 50 lakh. But in 149.2, 149.1, they say this criteria of asset expenditure entry will also be there, books, document, evidence, which is not there in 149 subsection 2. So why they have kept these 2 things separately? This is something not, I tried to check from memorandum also, and my all thoughts I can't reconcile. The sweet change is this, Jain Saab, they have reduced the time limit of reopening from the 149.1, which was 10 years, 10 years. They have now they say 3 years, 3 months and 5 years, 3 months. I repeat, 149.1, Gupta ji, 3 years, 3 months and 5 years, 3 months. Some people were asking why 3 months more. I can't find answer. I only said from a tukka point of view, it could be grace period. Somebody asked Goel Saab, they will always wake up at the end of the 3 years, 3 months, 5 years, 3 months. What is the fun of giving 3 months? So I don't know, Gupta ji will shed light on this. So change has been like this. They say, I don't know, Gupta ji, they are fighting in the courts and Supreme Court and High Court in the earlier litigation of Ashish Agrawal ki whether 6-year limit will apply or 10-year will apply. Now they have sensibly, rightly, they have reduced the time limit to 3 years, 3 months and 5 years, 3 months. When they have reduced it, they have definitely reduced it from the prospective effect. This will apply when the notice will come after 1st September 2024, sir. Not for the notices which have already come or which are in pipeline till 30th, what you say, this 30th August, sir. Am I right?
कपिल जी, मुझे लगता है कि ये 147 का प्रोविजन जो है ट्रायल एंड टेस्ट के ऊपर चल रहा है, बिल्कुल हर जगह पर नया टेस्ट चल रहा है और
एक सेकंड सिन्हा जी, हमारे प्रेसिडेंट साहब नाराज हो जाएंगे क्या है, उनका डिक्टम आ गया। देखिए सुप्रीम कोर्ट का डिक्टम और नारायण जैन जी का डिक्टम यहाँ सेम है।
बिल्कुल
आप उनके
बिल्कुल
बैलोनी करके लिए ना कहिए, मैं नहीं कर पाऊंगा सर, मेरे को इनसे मोमेंटो आशीर्वाद लेना है। 149 subsection 1, 149(2) is one change, Gupta ji, and this 152 I have discussed. 151 also very Sinha sahab, very tricky. They say now. Earlier they were very enthusiastic. Now when the case will be reopened beyond 3 years, approval of chief commissioner will be there, Gupta ji, and below 3 years commissioner. Now I don't know what prevailed on them. All of a sudden they say in 151 now approval will be of additional commissioner and joint commissioner only. All of a sudden you have changed the authority from top to low. Sorry, top to low means chief commissioner was one authority who was approving a case beyond 3 years, and below 3 years commissioner. Now you say across board there will be a single approving authority, namely additional commissioner and joint commissioner. I don't know. They can make the change as Sinha ji was rightly saying. I don't know what at one time they were thinking that cases should be reopened with stringent measures and stringent approval from highest authorities. Now they are thinking it should be from joint commissioner. 148 Gupta ji, they in 148 capital A, they have changed the sequence. 148A was earlier numbered as 148 capital A. I am talking about the procedure prior to 148. Clause A, B, C, D, they have done away with. They are inserting 148 capital A some subsections. The important change, Gupta ji, I found positive in 148A was that whenever new law, this after Finance Bill 2024, show cause will come in 148A. They have spelled out in 148A subsection 1, all relevant relied upon information will be given along with the show cause. That is very important. Earlier it was not there as such written in 148A. Now in 148A subsection 1, they have spelled out, Sinha ji, all show cause notice which will be issued in the amended law. It will also be accompanied with the background material and relied upon information and underlying documents and stuff, which they are not giving us till date healthily. I hope if the law is now amended and they have taken this point on board in 148 capital A in the statute, that will be sincerely obeyed by the authorities. In 148, again they have made structural changes. One thing they have, Gupta ji, kept is that survey wala part is in 148 only. Survey which will happen, which all will be under 148 law only, survey action, non-tedious survey action. And secondly, 135 capital A wala information wala will directly be under 148. No 148A will be there when information will be there under section 135 capital A. So 148 and 148A change is not too much. Apart from the fact they have excluded search. Search is taken in separate scheme, chapter 14B. And other things, they have information suggesting escapement of income criteria, etc. has been same. And the list of information suggesting escapement of income, Gupta ji, is almost same. That risk management strategy, audit objection, that court information, 135A wala information, survey information. So more or less, if I summarize it, Gupta ji, you may add, the time limit has been reduced from 10 years to upper time limit to 5 years and 3 months, and 50 lakh criteria has been capped. The extended period, the criteria of books, document, evidence, etc. has also been capped. Approval from higher authorities, CIT, CCIT has been changed to joint commissioner. And there is a sunset clause capped in section 153, subsection 2, subsection 3 and subsection 4, that qua notices which will be after Sinha sahab, after 1st September 2024. You know, Gupta ji, there is a very sentimental feeling here. People who will receive the notices after 1st September 24 and people who will be given the notices prior to 1st September 24, but courts have said lawmakers can put this, what do you say, criteria. As far as, you can add, Gupta ji, points here, your points, please. Well, your insights on that.
Kapil ji, in this section they have said 3 years and 5 years. I think the 3 years, 3 months is for giving the notice. And 5 years, 3 months is also for giving the notice.
Yes, sir. You are right. You are right, Purohit sir. Absolutely right, sir.
Sir, please.
You are right, Purohit sir. Absolutely.
Purohit sir.
Qua 149 subsection 2, the time limit, Gupta ji, is 3 years and 5 years.
May I add this?
Please,
Purohit
please.
sir, are you saying something? Yeah, Purohit sir.
मैंने म्यूट कर लिया, बोलिए, मैं कुछ नहीं कह रहा हूँ, आप बात करिए।
नहीं
अरे नहीं सर, आपका आप भीष्म पितामह हमारे लिए, बोलिए सर, आपका यू आर ऑलवेज फॉर द टॉप।
नहीं सर, हाँ पुरोहित सर, आप कहना चाहते? हाँ जी, प्लीज। नहीं please.
Gupta ji, you can add your views.
हाँ सर, पहले जो 148 में जो टाइम लिमिट थी, उसमें 149 में there was a provided an exclusion for the time given for reply to the assessee.
Sir.
The notice was to be given under 148A. Then the opportunity was to be given, the assessee has to reply. And then the time limit at that time could be extended also by the assessing officer. And there was exclusion for the determining the tax limit, time limit, for the time provided to the assessee for the purpose of replying the notice under 148A. Right. Now there were a lot of confusion as regards exclusion of time limit. There were one particular clause, in fact,
yes,
which was never understandable.
Fifth
which
proviso
was
and fourth proviso, fifth proviso and sixth proviso.
Yes, that's proviso itself. Now with a view to simplify the things, they have gone by the presumption that after giving notice under 148A, there will be 3 months period will be taken in serving the notice, in getting the reply from the assessee, and then finalizing the order under section 148A.
Right.
For that purpose, 3 months time has been kept in mind.
Right.
And this is why it has been provided that notice under section 148A has to be served within a period of 3 years or 5 years respectively. And notice under section 148A has to be served within 3 years and 3 months, and 5 years, 3 months. That is what.
Absolutely, absolutely. You have rightly made it that this 3 months is for the extra work which they have to do.
Time period, which earlier exclusion was to be determined.
But there is one good thing, sir. One science, they want that they want department to complete their homework of 148A within particular time frame.
That has to be done, in fact. But earlier there was a very ambiguity, in fact, very much ambiguity. The time period could be extended.
गुप्ता साहब, इसका मतलब ये हो गया कि 148A का नोटिस जो वो विदिन 3 साल, वो 3 साल के भीतर
नहीं पड़ेगा, विदिन 3 years या विदिन 5 years देना है. उसमें जो पहले था 31 मार्च को दे दिया करते थे वो जो है, और उससे फिर वो जितना टाइम एक्सक्लूजन आप रिप्लाई करने के लिए कर रहे हैं, और उसमें देयर वाज एन ऑप्शन the assessee could request for the extra time.
ऑर्डर उसके बाद पास कर सकता है गुप्ता जी, ऑर्डर उसके बाद पास कर सकता है 3 महीने और एक्स्ट्रा में.
नहीं, कौन सा ऑर्डर, कब?
148D का ऑर्डर
पहले या आपको
जो अब नए वाले लॉ का जो ऑर्डर बनेगा फिट केस का,
नए वाले लॉ में 3 महीने का टोटल पीरियड है.
मैं ये कह रहा हूँ कि जैसे उन्होंने 3 साल के अंदर, जैसे मैं एक बात, सॉरी, जैसे 3 साल में 5 साल में मुझे 148 कैपिटल ए का शो कॉज आ गया सर, उसके बाद जो फाइनल फिट ऑर्डर पास कर रहा है न्यू 148A में भी, तो फिट ऑर्डर तो पास होगा सर.
हाँ, तो वो 3 महीने का विदिन 3 months. assessee को भी टाइम देने में विदिन 3 months ड्यूरिंग द टोटल पीरियड 3 months.
दिस इज हाउ इट इज बेटर एक्सप्लेन.
यस प्लीज.
कपिल साहब यहाँ पर मान लीजिए 3 साल 1 महीने में 148(1) का नोटिस दिया, और फिर 5 साल में 5 साल 1 महीने में दिया, और बाकी 2 महीने में वो काम कर लिया. इट इज पॉसिबल?
नहीं, नो पॉसिबल, नॉट पॉसिबल.
नहीं,
ये तो सब एक्ट में लिखा हुआ नहीं है.
लिखा है
3 साल के अंदर ही उसको देना पड़ेगा.
नहीं, लिखा है ना.
हमारे स्पीकर कपिल जी को बोलने दीजिए. काइंडली पुट योर ऑब्जर्वेशन एट द एंड. Kapil ji, may I request you to continue kindly.
Sir, chapter 14 now, sir. Yes, sorry. Chapter 14B regarding search assessment, Gupta ji. As much as I can understand, though they have taken it from the what you say, there is a very interesting thing, Narayan Jain sahab. They say that when in 2021 they have merged search assessment into 148. In 2021, and we are 3 years hence, they say that in the memorandum that lot of problems have been found in the 148 qua deemed escapement of the search cases and other cases in explanation 2 to 148. Now, the legislature has rightly find there is a problem. Gupta ji, there is a disease or there is a something problem. Now, cure which is being given now is like this. According to them, they say cure is this, ki we are inserting now separate chapter for the search assessment, which is you say the next avatar of the block assessment, which was earlier there, but it is in a very different form. As I could see, Gupta ji, the definition of the undisclosed income and the basis of the new block assessment, as courts have interpreted in the favor of assessees many times in the earlier block assessment, they have plugged all those loopholes in the favor of the assessee. Again, now they have captured it against the assessee, as I could read. For example, they say while making the search assessment in the new regime, which will be applicable qua searches after 1st September 2024, they can also factor into the things which comes to the notice of the AO during the course of the proceedings. I was myself debating what is the connotation of this word comes to notice, sir. In the search assessment, when you are making a special assessment, and when I have not found anything, Gupta ji, incriminating material, can the AO go back to again that de novo assessment concept and making routine issues and making inquiry on those, all those aspects where nothing emanates from the search? So that is one thing which I find very strangely worded in this new law. Maybe you can correct me, in the new block assessment scheme, when they have defined what will be undisclosed income, or what will be the basis of assessment of undisclosed income, that was apprehending me. Rate of assessment of undisclosed, the period which will be covered is 6 years plus the period till date of search, Gupta ji, that is block period, if I'm right. 60% will be the tax rate under section 113. And penalty in the block will be 50% of the tax. That is discretionary, but 50% of the tax. So I again feel, now when they have found this, Gupta ji, the section 148 deemed escapement problematic, no cure is given for that. They say that will go like that. They have specifically stated in section 158 BI that only new block assessment will apply qua searches after 1st September 24. Section 158 B capital I. Now, for the searches, Gupta ji, which have already taken place prior to 1st September 24 and after 1st April 2021, the assessment will be taken place as per the provisions of the law prior to Finance Bill 2024. That is in 148. I was myself asking question to myself, sir, ki whether that problematic assessment will be the fate of the people who are searched during 2021 to 2024 is the mandate. So, Jain sir, you are president of our AIFTP, sir. This is my humble suggestion. Maybe Gupta ji will, I don't know, Gupta ji will correct me. That if there is a problem being detected, and they themselves have said that yes, for the this deemed escapement provision was not working well, all is not well with that. But the cure is not given for that. Cure is given for the period of searches after 1st September 24. I don't know what is the this correlation between the cure and the problem, Gupta ji. So that problem will go now, which they have identified, that problem will go with those cases which will be searched till 30th August 24. So anyhow, I believe, Gupta ji, we will have to have, see, from litigation lawyers' point of view, like Kapil, Goel, sir, definitely one judge was making our Delhi High Court judge sahab, that it is good that litigation lawyers, Gupta ji, will definitely be better off by this kind of changes which are on a testing mode, as Sinha Sahab was saying. 1995 block assessment came, then 153A came in 2003, then 2021 new 148 came, and in 2024 जैसे महाभारत के टाइम वो पहिया था ना, वो सब वैसे ही चल रहा है, मुझे लग रहा है. और मुझे ये कहते हुए, सॉरी गुप्ता जी, गुस्ताखी माफ करके कह रहा हूं, मुझे समझ में नहीं आता कि ये एसएससी का प्रारब्ध है या ये सब जैसे एसएससी के साथ होना ही है. ठीक है, हम लड़ेंगे गुप्ता जी, इंटरप्रिटेशंस आएंगी, सुप्रीम कोर्ट अगले 20 साल में अभिसार बिल्डवेल जैसे 20 साल में आया था, अगले 20 साल में फिर कोई अभिसार बिल्डवेल आएगा उसके लिए. जब तक पता नहीं मैं रहूंगा नहीं रहूंगा मुझे नहीं पता. I don't know. I'm not a negative man, but I have my serious reservations on these changes which are so fast happening in such a critical subject that you have no stability of the law, as Jain sahab was quoting Palkiwala sahab. So that he used to say, somebody was saying ki last day Amarjit Chopra sahab the, that it is like a railway ticket now for a one journey budget. So is it rightly happening that you are saying it is, see, you are making changes, Gupta ji, so serious changes, and that too with such speed that in 3 years you have found that what 2021 not working well and no cure for that. People are fighting for that, and I don't know वो litigation तो कब खत्म होगा गुप्ता जी, पर उससे पहले हमारे पास नया सेक्शन आ गया, उसके लिए हमें अलग तैयार रहना है.
एक्चुअली क्या हो रहा है सर कि जब तक कोई पॉलिसी मेकर, एक मिनट टाइम ले रहा हूँ, जब तक पॉलिसी मेकर हाई कोर्ट और सुप्रीम कोर्ट के डिसीजन को देख देख करके लॉ बनाते रहेंगे ना, तब तक ये अमेंडमेंट करते रहेंगे.
गुप्ता जी आप अपना वक्तव्य, सर थैंक यू सिन्हा साहब, आप अपनी, मेरे पॉइंट सर मैंने बता दिया सर असेसमेंट पे, मेरे को तो जितना समझ में आया सर ये जो मैंने बोल दिया. यू कैन ऐड योर थॉट्स ऑन दिस गुप्ता जी.
जैन साहब, विल यू लाइक टू ऐड? जैन साहब,
because there are very serious changes, sir, I believe.
Jain Sahab, particularly, Jain Sahab is expert on such matters.
Yes. Narayan Jain Sahab is expert, sir.
Narayan Jain Sahab, sir.
कपिल जी ने सब चीज बहुत अच्छा से बताया है. इनका कल का भी एक वीडियो मैंने सुना, और क्या है कि इनका तो जितने बार भी सुने तो बात यह है कि एक लाइन का है कि दिल मांगे मोर. तो हम आने वाले समय में और भी इनको बार बार जो है हम लोग के बीच जो है चेष्टा करेंगे कि इनको पाए और हम लोगों की ज्ञान की वृद्धि
तो अभी
हो।
मैंने खत्म नहीं किया अपना सेमिनार, सॉरी।
हाँ, प्लीज
आप
कैरी ऑन, प्लीज
आपसे
कैरी
कमेंट
ऑन,
मांग
प्लीज कैरी ऑन।
नहीं, मैं तो आपका वक्तव्य, हम तो गुप्ता साहब आपको पूछ रहे थे कि आप इस पे कुछ सर्च असेसमेंट में अपना प्रकाश डालना चाहे, लाइट शेड करना चाहे, क्योंकि आप बहुत ज्यादा इस पे ध्यान रखते हैं, तो आप कुछ बोलना चाहे बोल सकते हैं सब, प्लीज।
इज ऑल राइट, प्लीज प्रोसीड।
तो गुप्ता जी, यू कैन ऐड प्लीज।
Kapil ji, I think basically
please carry on.
because unless incriminating material was found, 148 notice could not be given. That's what the Supreme Court has held. So in assessment, they will now open 6 years cases and make addition wherever required based on the incriminating material found.
Sir.
That they want to reduce the litigation probably.
Sir, nahi, Purohit sahab, I'm sorry.
Sir,
Kindly, I will just say, Gupta ji, this section, kindly note 158BB subsection 2, I'm reading, sir. It says the undisclosed income falling in the block period forming part of total income referred to in subsection 1 of section 158BA shall be computed in accordance with the provisions of this act. Now, please take note, Purohit sahab, of these words. On the basis of evidence found as a result of search or survey. Now, survey or survey, किसी के और के survey or requisition of books, etc. and such other material or information as are either available with the AO. Now, this clause I am very difficult, or comes to his notice during the course of proceedings under this chapter. Gupta ji, this or comes to his notice.
Sir.
The scope has been widened now.
Purohit sir, sir, इसमें जो आप कह रहे हैं ना, जो incrementing material is found and only for those assessment years the assessment can be done. Sir, as far as that was the law prior to this 2021. Before 2020, 2003, there was a concept of block assessment. And now they have brought the concept of block assessment. There will not be 6 assessments for different assessment years. There will be one consolidated assessment for all the 6 years. That is the difference. And now there is no separate reassessment or regular assessment also. All the assessments which are pending or which have been concluded, everything will become part of this, and this will be the assessment for the full period of 6 years plus date of research. And they have described what is the total income, what is the undisclosed income. For the purpose of undisclosed income, they have given a definition. What it means: the total income assessed by the assessing officer, less the return income declared by you in the return filed by you for the block assessment year, or the assessments already done for respective assessment years. That difference will be there. So what Kapil has been saying, that now he can do anything. He can make their sort of a regular assessment. Right. In fact, that is the intention. Right. That they will make the assessment like a regular assessment for all the period of 6 years, and they will determine the total income. And then on that basis, the assessment or tax liability will be determined. And for the purpose of 60% rate only, they said that rate will be there also. They have set the total income for the one fund. There is a rate has been prescribed. There also the rate. So they also, yes.
Scope of assessment has been widened. This is the earlier.
Right.
May I add something here? In this provision also, it has been said that pending assessment shall abate.
Naturally.
So, just similar to the previous regime. It does mean that there will be some assessment which has been completed. And for those completed years, unless there is incremental material, addition cannot be made. So whatever assessment producer has been laid down in this current block assessment, only those pending assessment which can be reassessed and all undisclosed income can be added.
No,
Am
sir,
I correct,
no, sir.
Kapil ji?
No, Parsuga ji, आप उसको जो पढ़ रहे, sorry, Gupta ji will clarify. I'm telling you, sir. अगर ऐसा होता ना, तो सॉरी, 2 बातें हैं सर. पहली बात तो उनको इस तरीके से दोबारा ब्लॉक असेसमेंट लाने का जरूरत नहीं पड़ता. और दूसरा जो उनका इंटेंशन है, जैसे गुप्ता जी ने भी बोला मेमोरेंडम में सब जगह, they want to come out of this thing of incriminating material and everything. They want to give free hand to the AO to, sorry, I'm using this phrase with due respect, through the taxpayer, that everything and anything they can assess under the sun and moon.
Right.
Under this umbrella of this block assessment, if I'm not wrong, Gupta ji.
This will be like a regular assessment.
Abatement का मतलब क्या हुआ?
Kapil ji, undisclosed income तो अभी भी on the basis of incriminating material ही होगी. Kindly say 158BB2.
Yes, ma'am.
158BB2 देखिए आप.
Right, ma'am.
The undisclosed
वही मैंने पढ़ा था, मैम. उसका लास्ट वाला लाइन.
The block period shall be computed in accordance with the on the basis of evidence found as a result
बट आप
of
उसके लास्ट वाला लाइन पढ़िए मैडम, पूरा पढ़िए उसको।
or survey revision or other and
अरे ये
such
सर्वे भी
other
बहुत,
matter
एक तो
as
सर्वे
a
वाला
right
मटेरियल भी आ गया। हाँ, लास्ट वाला कम्स टू नोटिस,
during the course of
कुछ भी कम्स टू नोटिस हो गया तो सब कुछ आ गया उसके पास। और दूसरा आप उसका इसका डेफिनेशन पढ़िए एक बार, जो सेक्शन 158 कैपिटल बी में क्लॉज बी में अनडिस्क्लोज इनकम की परिभाषा दी है, वो देखिए आप।
हाँ सर,
उसमें कौन सी बुक्स एंट्रीज की बात कर रहा है मैम, वो देखिए आप। वो जो किताबों में आपका लिखा हुआ है उसको भी वो कर सकता है अगर उसको गलत पाया गया। गुप्ता जी 158 कैपिटल बी क्लॉज बी में जो अनडिस्क्लोज इनकम मीन इंक्लूड्स इंक्लूसिव डेफिनेशन एनी मनी बुलियन ज्वेलरी वैल्यूएबल आर्टिकल एक्सेट्रा एनी मनी बेस्ड ऑन एंट्री एक्सेट्रा वेयर सच मनी बुलियन और एक्सेट्रा रिप्रेजेंट्स होली और पार्टली मैम which has not been or would not have been disclosed or any expense deduction etc claim which is found to be incorrect. So after this when they have जो आप पढ़ रहे थे 158 BB subsection 2 that was very typical ma'am, comes to notice they have used some at different places कि to give them this Paransuka this wider ambit to them। जो पहले वाला 158 आप एक तो जब आप इसको बारीकी से कंपेयर करेंगे ना, इफ यू वांट टू कंपेयर गुप्ता जी, जो पुराना 1995 में जो जब मनमोहन सिंह साहब लेकर आए थे मेरे ख्याल से जो ब्लॉक असेसमेंट, उसको आप कंपैरिजन करेंगे परंसुका जी इस वाले ब्लॉक असेसमेंट से, तो क्लियर हो जाएगा आपको बिल्कुल कि वो जो चीजें हैं कि हिडन, जैसे कहते हैं ना, कहां आपको हिडन चीजें नजर आएगी वो पता लग जाएगी आपको।
सर इन्होंने इसमें 148 और 153C 153A दोनों का मिक्सचर कर दिया है कि
दिस इज द राइट व्यू, यू आर एब्सोल्युटली राइट। नाउ दिस
कुछ प्रोविजन जो बेनिफिशियल था रेवेन्यू के लिए वो
इसी
सारा
तरीके से
उसमें
असेसी
mix
को
करके
पकड़ना है,
इसमें डाल दिया।
सॉरी कि असेसी चला ना जाए, मतलब टेक्निकल पॉइंट पे छूट ना जाए।
सर एक बात कपिल, एक बात और बताऊं, आप ब्लॉक पीरियड की डेफिनेशन देखिए, वो भी बहुत टिपिकल है।
यस मैम।
Block period means the period comprising previous year relevant to 6 assessment years preceding the previous year in which the search was initiated under 132 or any regular. There is no problem till here. First day of April of the previous year in, अब यहाँ से 132 है, यहाँ से देखिए, and also includes the period starting from the first day of April of the previous year in which search was initiated or requisition was made and ending on the date of execution of the last of the authorization for such search or requisition। इसका मतलब कि जिस साल में सर्च हुई है उसका 1 अप्रैल से लेकर और जहां तक लास्ट ऑफ द ऑथराइजेशन एग्जीक्यूट हुआ है, समझो 4 महीने बाद हुआ कि 6 महीने,
ब्लॉक पीरियड में आएगा,
ब्लॉक पीरियड में आ जाएगा। नॉट ओनली 6 असेसमेंट ईयर्स,
यही बताया था कपिल ने, शुरू में
टूटा पीरियड भी उसमें आ जाएगा।
हाँ हाँ बिल्कुल बिल्कुल, आप ठीक कह रहे हैं, कपिल ने शुरू बिगिनिंग में यही बताया था। पर मैडम ये असेसमेंट के लिए 158 BA का 1B पढ़े हैं कि असेसमेंट कैसे होगा।
हाँ 158
सर लेकिन ये एबेटमेंट का मतलब क्या हुआ कि एबेटमेंट
आपको मैं बता रहा हूं, मैंने पढ़ लिया। गुप्ता जी की बात करते करते एक चीज नोट कर ले परसुका साहब, आप यू विल डेफिनेटली अप्रिशिएट इट। इसमें जो इन्होंने पहले वाला जो पुराना 140 जो ब्लॉक असेसमेंट था आप उसका नोट करिए, सेक्शन 158BB को आप पुराने वाले को कंपेयर करेंगे ना, मैं बात करते करते कर लिया, उसमें ये जो सब वर्ड कम्स टू नोटिस वगैरह ये ऐसा कुछ नहीं था जो इन्होंने अब डाला है।
सर वो 148 का ले आए यहाँ पर, जो 148 का थर्ड एक्सप्लेनेशन था जो शुरू में,
यस मैम,
वो यहाँ पर ले आए।
यस मैम, यस मैम, यस मैम। गुप्ता जी
158 BA के हिसाब से देयर विल बी वन असेसमेंट फॉर द टोटल ब्लॉक पीरियड, notwithstanding and continuing other provisions of the act, where on or after so and so a search is initiated under section 132 so and so in case of a person, then the assessing officer shall proceed to assess or reassess the total income of the block period in accordance with the provisions of this chapter. So there will be one assessment for the total block period. एंड अबेट का मतलब यही है कि वो खत्म हो गया, वो इसमें मर्ज हो जाएगा।
अब एक चीज गुप्ता जी, जैसे जो मैं पढ़ रहा था, सॉरी कमिंग अगेन, जैसे बात परसुका जी जैसे कम्स टू नोटिस है, यू अंडरस्टैंड इफ प्रैक्टिकली सी कि अगर पोस्ट सर्च इन्वेस्टिगेशन में कोई रिकमेंडेशन इन्वेस्टिगेशन विंग ने अप्रेजल रिपोर्ट में किया या कोई पोस्ट सर्च इन्वेस्टिगेशन में उसको बोला एओ को करने के लिए, तो वो क्या डिपार्टमेंट तो यही बोलेगा कि तो कम्स टू नोटिस में आ गया।
यस यस
सर, आई एम ऑन द सेम पेज, बट ओनली आई वांट टू नो दैट वो एबेटमेंट वाली बात
आप सही कह रहे हो सर, वो बात तो है। अब उन्होंने तो उसको पता नहीं है, ये जो आप बोल रहे हो 140 जो 158 BA में जो सबसेक्शन 2 आप बोल रहे हो वो है तो सही डीम्ड अबेटमेंट वाला, बट अब जो जिस तरीके से इन्होंने उसको वर्ड किया है, मुझे तो यही समझ में आया
कि जो असेसमेंट पेंडिंग नहीं है
हाँ जी
और एबेट हो गया, उसमें ये सारी बातें लागू होगी।
सर अब पता नहीं ये फ्रेश राउंड ऑफ लिटिगेशन गुप्ता जी कैसे चलेगा, तो वक्त बताएगा परसुका जी। यही मैं कह रहा हूँ कि ये क्या देखिए 20 साल लग जाएंगे अगले भाई साहब आने में। एमआर शाह साहब का वो अभिसार बिलवेल साहब का ऑर्डर 20 साल लग गए। 153 आया था गुप्ता जी 2003 में, और उसका पहला सुप्रीम कोर्ट का जो फाइनल ऑर्डर आया वो अभी आया पिछले साल। 20 साल की उसका जेस्टेशन हो गया। अब हम 2024 की बात करें, पुराने वाला तो अभी सेटल ही नहीं हुआ 140 डीम्ड एस्केपमेंट, वो तो अभी लड़ रहे हैं लोग। मैं एक चीज और बता दूं गुप्ता जी, रह जाएगी इसमें, एक बड़ी इंटरेस्टिंग चीज मुझे नजर आई सर, कि ये कह रहे हैं पेनल्टी से अगर एसएससी को मुक्ति मिल जाएगा 150 जो नया लॉ है 158 बीएफए वाला, दैट इज ए आई एम रीडिंग 158 बीएफए सबसेक्शन 2 का प्रोवाइजो। दे से नो पेनल्टी अंडर दिस सेक्शन ब्लॉक असेसमेंट एंड सेक्शन 271 AAD 271D 271D एंड 271 EV लीवेड फॉर ब्लॉक पीरियड इन रिस्पेक्ट ऑफ ए पर्सन। अगर उसने रिटर्न में जो दिखाया है उसका टैक्स वगैरह पे कर दिया है और उसको असेसमेंट में नहीं लेकर गया है, तो दिस इम्यूनिटी फ्रॉम पेनल्टी व्हिच दे हैव गिवन इन दिस 158 बीएफए सबसेक्शन 2 पर सुका जी कैन बी नोटेड डाउन। दैट इज ए वेरी एडिशनल इम्यूनिटी। वो सिर्फ ब्लॉक असेसमेंट की पेनल्टी की इम्यूनिटी नहीं है, उसमें 271 AD की पेनल्टी, 271 D की पेनल्टी, 271 DA की पेनल्टी एंड 271 E की पेनल्टी, चारों पेनल्टी और इंक्लूडेड है गुप्ता जी।
यस यस
हाँ जी बिल्कुल ठीक कह रहे हैं।
और एक चीज मैम इसमें मुझे और टिपिकल लगी, क्योंकि वो सेक्शन बहुत तंग करता है हमेशा की, जैसे किसी के सर्च हुई और किसी दूसरे का केस खुल गया। अब इस बार का 158 बीडी गुप्ता जी अगर खोल के पढ़े, जो नया 158 बीडी बता रहे हैं, जो पुराना 158 बीडी था उसको कंपेयर ध्यान में रखते हुए ये कह रहे हैं वेयर द एओ इज सेटिस्फाइड दैट एनी अनडिस्क्लोज इनकम बिलोंग्स टू और pertains to or relates to. Now I ask a question myself, ma'am, how can undisclosed income be relate to and pertains to? Belong to तो चलो समझ में आ गया, लैंग्वेज इज 158 बीडी काइंड ऑफ ए गुप्ता जी।
भाई साहब पहले जो कंट्रोवर्सी थी वो खत्म कर दी ना उन्होंने।
अरे सर मेरे को ये समझाइए, नहीं नहीं मुझे एग्जांपल ये नहीं समझ में आ रहा।
पेप्सिको
इसमें बच जाओ जो पहले जो
no,
झगड़ा
ma'am,
था
sorry,
कि बिलोंग और पर्टेन और रिटेन
any entry that is Kapil in respect of any entry pertains
what I'm
to
submitting is that
in
if
the
you,
books of
what I'm
accounts.
submitting is that there are two types of things for which 153C could be done. 153C की लैंग्वेज को आप ध्यान रखें, उसमें था इंफॉर्मेशन भी गुप्ता जी, डॉक्यूमेंट भी, बुक्स भी और मनी एक्सेट्रा भी। मेरा कहना यह है कि आज अगर अनडिस्क्लोज इनकम में वो लिखते हैं आगे बिलोंग्स टू, पर्टेन्स टू एंड रिलेट्स टू, डॉक्यूमेंट बिलोंग्स टू, पर्टेन टू, रिलेट टू समझ में आता है इंफॉर्मेशन सर। हाउ इनकम पर्टेन्स टू, रिलेट टू समझ में आ रहा है, मेरे को नहीं आ रहा समझ में सर, सॉरी मुझे आप बताइए।
सर इस इनका मतलब यही है कि अनडिस्क्लोज्ड इनकम ऑन द बेसिस ऑफ एनी एंट्री इन द बुक्स ऑफ अकाउंट्स रिलेट्स टू और pertains टू, क्योंकि पहले भी यही था pertains टू लाने का मतलब।
ये बहुत ज्यादा डेंजरस सेक्शन अब इन्होंने मुझे
सर,
लगता है
कपिल इसमें एक इम्पोर्टेंट बात 158 बीडी में
इसका
जो
मतलब,
मुझे
सॉरी मैम,
नजर आई कि सेकंड सेटिस्फेक्शन डिस्पेंस विद कर दी है।
नहीं उससे पहले मैडम इसका मतलब ये हुआ कि प्रोटेक्टिव बेसिस पे 158 बीडी हो सकता है। What I am submitting in the new law 158 BD, if you read the starting two lines, it suggests, in my humble respectful opinion, Gupta ji, if I am not wrong, that it gives an indication that 158 BD can be launched on precautionary and protective basis also.
प्रोटेक्टिव का सवाल ही नहीं है, वो तो कहेंगे इसको बिलोंग करती है उसका।
सर्च असेसमेंट तो प्रोटेक्टिव हो ही नहीं सकती।
मेरा लास्ट गुप्ता जी तो खत्म हुआ। लास्ट चेंज जो मुझे इंपॉर्टेंट लगा, सेक्शन 251 में दे हैव गिवन पावर टू द सीआईटी अपील दैट ही कैन सेट असाइड द असेसमेंट ऑफ 144।
Yes. That was earlier very much difficult. That was
so with this, Gupta ji, I come to the end of my deliberation. Narayan Jain ji, I don't know, ma'am. All of you are my senior, and Gupta ji, Prem, Lata, Bansal, ma'am, Purohit Saab, Narayan Jain ji. I don't know how much justice I could do to the duty given to me, but I tried my level best. Even if there are shortcomings.
I just want to ask you something.
Sir.
See, they have given immunity penalty under section 271, AAA, 271C, etc.
Sir.
Probably intention is, and it has been also widened for the assessments those abated.
Sir.
This, that if the block assessment is done, thereafter the regular assessment will not be made.
Sir.
And they will only give you set off of the income disclosed in those returns. That may be the intention. Earlier, otherwise, even in spite of block period assessment, The regular session is separately made.
Gupta ji will comment. Gupta ji, you want to
नहीं
add?
नहीं बिल्कुल ठीक कह रहे हैं सर, ठीक कह रहे हैं बिल्कुल. ये that is what I said कि now the assessment will be one only for the total block period. There will be no separate assessment for each of the years. All the assessments which have been already been done will also merge in this. So that is what the intention is.
But it will
No,
be really very, very interesting, Gupta ji, for the people whose search has already happened. I again come, who that will be assessed by the central circle in the earlier 148 wala thing. And now this chapter 14B Mehta ji has been inserted. Now the same officer, Gupta ji, will have to make a very serious compartment in whose case you are applying what. I don't know. See, with keeping my finger crossed, let us, I believe everything will be go well, that they will be able to apply the right provision to the right person in the right manner.
सर अपने को तो फायदा मिलने वाला है, आप चिंता मत करिए.
तो वो मैंने पहले कह दिया सर, इसलिए मैंने पहले कह दिया पुरोहित साहब, और मैं अपनी वाणी को विराम देता हूं सर. आई हैव टू कैच द प्रोग्राम आल्सो, सो आई डोंट नो, मतलब आप सबके आशीर्वाद मुझे आज मिला. आई एम ब्लेस्ड एंड आई एम लकी. आप सबका आशीर्वाद मुझे मिलता रहे इसी तरीके से. जैन साहब, आई ट्राई टू गिव माय थॉट्स एंड ऑल माय सीनियर्स, प्रेमलता मैम, पुरोहित साहब एंड एवरीवन सर. गुप्ता जी,
थैंक यू कपिल, थैंक यू लॉट.
फ्रेंड्स, आज का डेलिब्रेशन अलौकिक और अद्भुत रहा. Undoubtedly today's deliberation of Mr. Kapil and debate and discussion of all the participants and seniors mesmerized all the participants. Undoubtedly all are benefited. Yesterday we have seen the presentation of our Sitaraman, Finance Minister. उनका कौशल हमने देखा, और today we have witnessed the explanation of all the amendments. Kapil ka kamal, and we thank Mr. Kapil, and we hope that all the time to come he will come on our invitation.
मैं इसके लायक नहीं हूं सर, प्रॉस के, आपका उदारपन है. गुप्ता जी कैन एंड कंक्लूड सर.
थैंक यू सर. डीएम भट्टर साहब है बंगलौर से, वो कुछ कहना चाहते हैं. डीएम भट्टर साहब.
Yes sir, yes sir.
Yes, बोलिए.
Good evening, Mr. Goel sir. It was fantastic,
sir,
and we could able to follow your speed.
I was very slow, and therefore I tried to incorporate ma'am's, Premlata ma'am's, Gupta's, Rohit saab's views. I was not going solo. It is a joint performance.
Yeah. It was good, sir. Good session. Sir, my personal and from All India Federation South Zone से एक बुलाओ. हमारा NTC Mysore 3rd, 4th and 5th. 3rd is NEC meeting is there, and EOGM also is there.
Yes, sir.
Plus NTC is on 4th, and our tax practitioner day, National Tax Practitioner Day is on 5th. So I invite everyone, please join, register today itself, and you can visit the Mysore place. It is a beautiful weather. Also is very, very good, and with your knowledge, we'll have something. We can have your knowledge sharing with us. So I invite personally, sir. Please.
Thank you, sir.
Please
So kind
join.
of you, sir. I am obliged and beholden.
Yeah. Please, sir. Please.
Sir,
Thank you, sir. Thank you, President ji.
Thank you.
Sir, I'm thankful to the Kapil for accepting the invitation and be available today. And I am also thankful to Jain Saab, Ganesh Purohit sir, Prem Bansal ji, and also Rajesh Mehta. So for joining today and be part of this deliberation. So everybody has contributed. I'm thankful to everyone and all the delegates also who have joined online. We have good number of delegates today online, more than 200 and all that.
No, one time to 250, more than 250.
Yes.
265. 265.
So it has been very welcoming thing. Right. Thanks a lot.
प्रणाम गुप्ता जी, सबको प्रणाम.
Thank you Kapil. Thank you Kapil.
Thank you Gupta ji.
Thank you sir.
Thank you. Thanks a lot. Thanks a lot.
Well done.
That's at one point of time, Sri J.K. Mittal was with us.
Sir.
And I think Mr. Samir Jani is still there. Samir भाई आप कुछ बोलना चाहेंगे? Samir Jani जी? Anyway, This has been very memorable, and we thank Sir Kapil Goel, all our past presidents, VP Gupta ji, and all of you. Thank you very much.
Thank you.
Thanks
Thank
a
you.
lot. Thanks a lot. Thanks to everyone.
Thank you.